Wonderful. I think we'll kick off. We've got a nice number of people attending, so thank you very much, everyone who's joined in, whether very early morning over in UK. Thank you very much, Sophie, and other people dialing in from Europe and elsewhere. And good afternoon here in Australia. So welcome, everyone, and thank you for joining today's webinar hosted by the LAWASIA Environmental Lawyers Network. I would just like to begin by acknowledging the traditional custodians of the land on which I'm dialing in from today, being Sydney, the Gadigal people of the Eora Nation. And I'd like to extend my acknowledgement to those connecting in across the country and across the world, and pay my respect to their elders, past and present. So my name's Lily Morton. I'm a lawyer in the Climate Change and Sustainability team at Gilbert and Tobin in Sydney. I'm also a member of the Environmental Law Committee at LAWASIA, being, for those of you maybe less familiar with the association, a really brilliant network of lawyers, judges, jurists, and legal organisation across the Asia Pacific and increasingly across the world, which is great. And we've also set up the LAWASIA Environmental Lawyers Network recently, bringing together like-minded environmental legal professionals and hosting events like this. So for today's webinar, being the fifth in our Environmental Lawyers Network webinar series, I'm very fortunate to be joined today by two leading global experts on climate and environmental law, Associate Professor Jolene Lin and Sophie Marjanac, to discuss a very big and very topical issue on accountability for climate change and other environmental harms, looking at the role of the polluter pays principle and evolving human rights perspectives. So I'll introduce our wonderful speakers, but I really strongly encourage you to read their full bios, which are included in the webinar invitation, to fully appreciate the breadth of Jolene and Sophie's experience and expertise. So Jolene Lin is an associate professor at the Faculty of Law at the National University of Singapore and director of the Asia Pacific Centre for Environmental Law. Jolene is a world-leading expert on climate law and transnational environmental law and has published widely on both topics. Jolene holds a PhD from the Erasmus University of Rotterdam, a Masters of Law from New York University, and a Bachelor of Law from the London School of Economics, and is an advocate and solicitor of the Supreme Court of Singapore. Thank you very much for joining us today, Jolene.
Thank you for the kind welcome, Lily, and thank you also for the invitation to present on this webinar. I see some familiar names in the people who are attending, so thank you very much and lovely to have you here. So Lily, I think I'm going to share screen first.
Yes, Jolene, I will just very quickly introduce Sophie and just touch on a
I'm
few
so sorry.
No, that was my fault, sorry. Very small housekeeping, and then I will hand over you to kick off the presentation and share your wonderful slides. So joining Jolene today, we have wonderful Sophie Marjanac, who is currently the Director of Legal Strategy at the Polluter Pays project in the UK. Sophie was formerly a lawyer at Client Earth, where she worked on Client Earth's leading climate litigation practice, including its work to hold corporations to account for environmental impacts. Sophie was also the lead lawyer in a case some of you may be familiar with, the groundbreaking Torres Strait climate case, which was the first climate case to be brought against the Australian government on human rights grounds. And Sophie is previously from Australia and a solicitor in Australia as well, and is now based in the UK. So thank you very much for joining us as well today, Sophie. Much appreciated, and very early for you. So thank you very much.
Thanks, Lily.
Thank you. I'm just going to pass over to Jolene to kick off today's presentation, but just on a short housekeeping note, just to keep the quality of the webinar running well, just with the amount of people we have on the line, do request that videos stay off for most of the presentation, if that's okay, and just if we could keep our microphones on mute, just to appreciate the wonderful experts' time today, just to keep away any background noise. And if you have any, so we'll open the presentation with some opening remarks from Jolene, who's kindly got some slides to share screen as well, who will help set the scene around what the polluter pays principle is and how this has been evolving in an international climate law sense. And then we will hand over to a presentation by Sophie, who will provide a bit of a tailored lens on the environmental harms aspect of the polluter pays Polluter Pays principle, and then we'll have time for moderated Q&A. So if you have any questions during the presentation, please feel free to pop that in the chat function at the bottom. If you'd also like to put in a message in the chat function introducing who you are and where you're dialing in from today, we'd also very much welcome that as well. So thank you very much. That's enough from me at the beginning, and Jolene, I'll hand over to you now. Thank you very much.
Thank you. All right, so I'm gonna share screen and okay, continue to share. Just share, continue to share. All right, are we good there, Lily? Can we see? Perfect. Thank you very much. So apologies for that false start. So today, as Lily says, I'll start with a brief overview, and let's move. And the outline of my presentation really would be on going to give a brief overview of the polluter pays principle in an international climate change law context. I will do so across three sub areas, and I'm just going to keep my presentation to hopefully I'll aim to finish in 20 minutes, so I'll give plenty of room for discussion as well in Q&A. So I'm going to be looking a little bit at how the polluter pays principle has been applied in some climate litigation across the global south. The reason being that it draws on a recent project that I've completed, a 3-year project looking at climate change litigation across the developing countries in Asia, Latin America, and Africa. Then I'll be touching on the International Court of Justice Climate Change Advisory Opinion, the comments that were made in this advisory opinion on the polluter pays principle and its relevance in relation to states' obligations in relation to climate change. And then I'll be looking a little bit on the recent advancements in climate attribution science. And I think that would just kind of segue into Sophie's presentation. So very briefly, in terms of some basic, introductory comments, which will, I suppose, be pretty much just about setting the scene. So first things first is that we all recognize that the polluter pays principle has been around for decades. It was adopted by the OECD in the 1970s, and it's an economic principle for the allocation of costs when it comes to pollution control. And in that regard, it has served as a policy basis as well as a normative basis to compel polluters to pay the costs of pollution. And then in the context of climate change, it is the basis for compelling polluters to pay the costs of the emissions, for the emissions of greenhouse gases. And when we look across domestic climate change policies, the introduction of carbon taxes and emissions trading schemes is often what we'll see as the operationalization of polluter pays principles in climate change policy. The polluter pays principle offers also support for imposing costs on private actors, such as shipping companies. Unfortunately, the most recent negotiations at the IMO, the International Maritime Organization, to impose a global carbon tax on the shipping industry. That attempt has failed due to intense lobbying by the United States Trump administration. But that is an example. The imposition of a carbon tax by the IMO would be the example of using, operationalizing the polluter pays principle in addressing climate change. And one of the things about the polluter pays principle is that it allows the assignment of responsibility to individuals and companies rather than states. So when we look across environmental law, the polluter pays principle is really a principle of domestic environmental governance. So in other words, states and countries, local governments, they are all encouraged to, or legally obliged, for example, in the European Union, to adopt laws and policies that internalize the cost of pollution and ensure that those who pollute pay to prevent the pollution or to clean up the pollution they have caused. It's interesting to note that the PPP, the polluter pays principle, is not widely seen as a principle of international environmental law that is applicable in interstate relations. It's not been seen as a principle of that allows or that should encourage, say, a state to sue another state because the state has polluted and caused environmental harm, even though there are other bases in international law for such accountability. But increasingly, we are seeing the polluter pays principle being talked about in the context of climate change accountability, in a sense of climate compensation cases, or what is widely now known as the polluter pays cases. So that is briefly on that. I wanted to draw on a few very simple examples, or just brief examples of how the polluter pays principle has been applied in climate lawsuits in the global south. So one example from Brazil. So in September 2024, there was a lawsuit filed seeking approximately US $115 million in compensation for climate damage caused by illegal cattle ranching in the Amazon. The case was filed by the Brazilian Attorney General's office, and it would be the largest climate compensation lawsuit that has been pursued in Brazil, and to the best of my knowledge, anywhere across the world, in the global south. So anywhere across the global south. The financial compensation that is being sought by the Attorney General's office was calculated on the basis of the social cost of carbon, and it is meant to be obviously a very important test case and if successful, would show that the polluter pays principle can be a basis for truly internalizing the cost of carbon, the cost of carbon pollution. And just to note that a few months before this case was filed, there was a Brazilian cattle rancher who was ordered to pay over $50 million in climate compensation for illegal deforestation. There have been similar cases filed in Indonesia, but the common problem that is faced both in Brazil and Indonesia in these cases, which are really important and have led to hefty fines being imposed. The problem is that the fines are barely ever collected. Oftentimes, the companies file bankruptcy or just completely disappear, and it's impossible to enforce the remedy. And this is something I think we all have to bear in mind when we talk about such cases. I'm just going to skip across this slide because it goes quite in depth into an example from India. But I wanted to, in this example, show that the polluter pays principle is part of Indian law. And I do have to give my acknowledgement to one of my colleagues, Shayan, for having really taught me a lot about polluter pays principle in Indian jurisprudence. And basically, the idea has been that the polluter pays principle in Indian environmental law has been a really important pathway for corporate environmental accountability. And in the recent cases in a recent case decided by the Supreme Court of India that recognized the right to be to a stable climate, or right to be free from the adverse effects of climate change. By making the link between that climate right and environmental right, I think the Supreme Court basically said that the right to a clean and healthy environment and the right to a stable climate are two sides of the same coin. By having made that reflection, it kind of creates this nexus between the environmental law jurisprudence and climate jurisprudence. So even though there hasn't been like a climate case that recognizes the applicability in the polluter pays principle, I think it is not too far-fetched to see how the polluter pays principle in Indian environmental jurisprudence can be applied in the climate change context. The polluter pays principle also was mentioned in the recent advisory opinion issued by the International Court of Justice in July this year. I'm just here reproduce two paragraphs, this side and on this slide and on the next, on what the ICJ had to say about the polluter pays principle as a normative basis or as a legal basis for state responsibility on climate change. Now, basically what the court had to say was that, well, first of all, in paragraph 159, basically stated that the principle of the polluter pays principle is not mentioned in the climate change treaties, whether it's the United Nations Framework Convention on Climate Change or the Kyoto Protocol or the Paris Agreement, but it is expressed in the Rio Declaration. So principle 16 of the Rio Declaration says that national authorities should endeavor to promote the internalization of environmental costs and the use of economic instruments, taking into account the approach that the polluter should bear. It should, in principle, bear the cost of pollution with due regard to the public interest and without distorting international trade and investment. So that is how Principle 16 is articulated. And as I mentioned it earlier in my first slide, the idea is that it has been an economic principle to encourage governments to put in place these kind of laws and policies that encourage the internalization of environmental externalities. So what it says there with paragraph 159 is that the court is saying, look, the polluter pays principle is not mentioned in the climate change treaties. So what does it mean? Now, it goes on to analyze that, or to say that it's a recommendation. So Principle 16 has been characterized by the court as a recommendation, and it observes that it has been followed by states in certain sector-specific treaties and various types of national laws, mostly in the form of strict liability for private actors for specific hazardous activities. However, they say that the principle is not envisaged or reflected in any of the treaties. And importantly, it goes on to say, nor has it been accepted that this principle applies directly in the relations between states without having been specified in a treaty. And it goes on to cite, some authorities. So accordingly, the court does not consider that the principle is part of the applicable law for the purposes of this advisory opinion. This does not preclude the possibility that forms of strict liability for hazardous acts and other kinds of acts that are not wrongful under international law are developing. Now, this conclusion was the subject of a comment in the separate opinion of Judge Badari, who had this to say. Well, I'm not going to read the entire paragraph, but I just wanted to point out that Judge Badari was of the view that the polluter pays principle is a critical tool in confronting the climate crisis. And he was disappointed. He said that yet the advisory opinion addresses it only in passing, limiting its treatment to 2 brief paragraphs. He goes on to say that the opinion appears to discount the principle's applicability solely on the basis that it is not codified in the treaties. And he goes on to say that this narrow approach overlooks the principle's broader normative and jurisprudential grounding in international environmental law. He goes on to analyze it a bit, and I think what would be something to take away from his comment is the last line of this paragraph 2, where he mentions that by failing to integrate that principle into its legal framework, the opinion misses an opportunity to strengthen the accountability architecture essential for addressing climate change. And I think this is something that we could, talk a bit more about in this webinar, especially as efforts are being ratcheted up to really, seek corporate climate accountability across the world. So very briefly, I'm going to touch a little bit on climate attribution science, because climate attribution science has been a really significant underpinning for many of the climate compensation lawsuits that are also characterized as polluter pays cases. So basically on the left-hand side of my slide, I've got 5 bullet points. And basically it kind of talks about the first one, there's trend attribution, event attribution, source attribution, impact attribution, and then basically the use of attribution studies in climate litigation. So basically what I think I wanted to kind of leave you with in terms of climate attribution science is this. Well, first of all, what is climate attribution science? I think it's important, like, first of all, to appreciate that scientists and lawyers talk about attribution differently. And there are obviously significant differences between scientific attribution and legal attribution. Nonetheless, both are very important, and scientific attribution is tremendously important in underpinning any lawsuit that seeks to attribute responsibility for greenhouse gas emissions to any corporate actor or state. So climate attribution science, the first thing that's really important for me in terms of understanding what its value is that it is about a counterfactual. Climate attribution science has been super helpful in helping us understand what exactly are the impacts of the contribution of human-induced climate change on our environment. So climate attribution science basically helps us understand the counterfactual of what is the world as it is, and what it would have been without this amount of greenhouse gases in the atmosphere, and what are the effects of that. The first wave of climate attribution science was really trend attribution, trying to understand how climate change had any relationship with weather patterns and sea level rise and that sort of thing, like trends. And then basically the subsequent stages in climate attribution science has been trying to improve our ability to attribute specific events to climate change impacts. And I think the next big leap was really source attribution, which was trying to make the connection between the event, like say wildfires, and the source. What would be the source or the significant source of greenhouse gases that would have led to the increased probability of these wildfires? On the right-hand side of the screen is basically a screenshot of one of the most recent and impactful publications in the journal Nature. And basically, it has been really significant in terms of its in this study, the researchers show the ability to attribute heat waves to the emissions of specific carbon majors. So it's really quite a significant step forward. And while there's still quite a number of pieces of a complex jigsaw to put together in terms of climate cases based on the polluter pays principle, this has been seen as a significant breakthrough in these efforts. So on that, I'm going to end here, and I'm really looking forward to learning from Sophie and from the rest of you. Thank you very much.
Thank you very much, Jolene. That was a fantastic overview of what the polluter pays principle is, how it's been developing for environmental and climate law issues, and that climate attribution science at the end is brilliant and stepping that through in those categories. I mean, for those dialing in from Australia or Sydney at the moment, you'll appreciate we're actually in the middle of an unprecedented heat wave. So understanding how that fits into all the climate change exacerbated effects that we're experiencing at the moment. So thank you very much, Jolene, for those opening remarks. I'm now going to pass over to Sophie to provide a slightly more tailored perspective of the polluter pays principle in the context of attribution for specific types of environmental harms, and Sophie's more recent and very interesting work at the Polluter Pays project in UK. So Sophie, I'll pass over to you now. Thank you very much.
Good afternoon, everybody. It's really nice to be here with you. I am suffering with a bit of a cold this week, so just excuse my voice, if you don't mind. I'm an Australian qualified solicitor, and as Lily said, the Director of Legal Strategy at the Polluter Pays Project. The Polluter Pays Project is quite a new organisation. I've been with them just for a year, and we are focusing on a very specific aspect of pollution, and that is decommissioning and cleanup of oil and gas assets at the end of their life. So Jolene's gone sort of wide, and I'll start wide, but then I'll also kind of really narrow in to talk about perhaps in a bit more detail how the polluter pays principle is actually applied in national law and in national contexts, and some of the challenges that states face when attempting to regulate business in line with the polluter pays principle. And we see not only in the global south, the polluter pays principle kind of falling short in reality, but we also see that across the global north, where there are huge issues with industrial processes. So I have not prepared slides. I'm sorry about that, so I'll just speak to my notes. So many industrial sectors, especially oil and gas, have significant decommissioning and cleanup liabilities at the end of the asset's life. And this is just a natural part of the industrial process. So there's always finite natural resources, and fossil fuels are finite, come to the end of their productive life, and then the asset or the mine or the oil and gas well which we focus on needs to be cleaned up, remediated, and the land restored to its previous state. So this would seem like a relatively basic part of environmental law in many countries. And it is. Most legal regimes around the world require the operator or the business to take responsibility for cleanup and remediation of land at the end of the license or consent to extract natural resources. So this is known as a decommissioning or remediation liability. And this is a separate and distinct legal obligation from the obligation to clean up operational incidents during the project's life, such as spills. And it's also a separate obligation to that which arises perhaps in tort law to compensate landowners affected by one's activities if negligence or nuisance claims can be made out. So the decommissioning and restoration obligation is a specific obligation on oil and gas and fossil fuel companies, and it's also called, in the United States particularly, it's called an asset retirement obligation. And as I've said, it arises under environmental and natural resource legislation. And these all arise from the polluter pays principle, which is, of course, best practice in environmental regulation. As Jolene said, the Principle 16 of the Rio Declaration noted that national authorities should endeavour to promote the internalisation of environmental costs and use of economic instruments, taking into account the approach that the polluter should, in principle, bear the cost of pollution. And really, as Jolene said, this is a concept from environmental economics, the idea that pollution is a negative externality of economic activity and a cost that's not borne by the producer. and thus economic efficiency requires that that cost be internalized by the polluter. And as Jolene's also mentioned, there's also a fundamental link to the concept of, no harm, you might call it in international law, and also negligence and nuisance in tort law that developed as industrialization was occurring in 19th century England. There were those original famous water pollution cases where downstream neighbors were affected by pollution from old industrial sites. And again, the polluter pays principle arose there at the common law, and also it has been codified into statute in many different ways. But the polluter pays principle is not universally formulated as one binding rule of international law, although I found it incredibly interesting what Judge Bandari said about the polluter pays principle. But it is somewhat fluid. It's an economic principle. It can be a policy guidance for decision makers and for policy makers. But also increasingly, it's a legal norm in domestic and regional lawmaking. So I just wanted to draw attention to two international treaties that you might not necessarily have heard of. These are two treaties that are relevant to the work that we do at the Polluter Pays Project. And that's because of our focus on oil and gas cleanup. And of course, you may or may not know, there are hundreds of old oil and gas platforms in the ocean, offshore around the world. Huge numbers around Southeast Asia, Malaysia, Thailand as well. And they are corroding, leaching toxic substances, heavy metals, lead, mercury. They also bring up, when an oil well is drilled, it brings up naturally occurring radioactive material. Excuse me. And it can have severely detrimental impacts on the marine environment, and that's well documented. One of the most important treaties that we deal with at the Polluter Pays Project is the London Convention and Protocol, and that is the international, also known as the Sea Dumping Convention. And the Sea Dumping Convention, the London Convention itself was signed in 1972. And the protocol, which was agreed by the parties in 1996, makes the polluter pays principle and the precautionary principle quite explicit. And that, I think it's one of the few treaties I've seen to actually do that. So it says in Article 3.2, provides for a precautionary approach to risks to the marine environment, stating that contracting parties shall apply a precautionary approach to environmental protection from dumping of wastes and other matter, whereby appropriate preventative measures are taken when there is reason to believe that wastes or other matter introduced into the marine environment are likely to cause harm, even when there is no conclusive evidence. So that's a clearly expresses the precautionary principle. And then, excuse me, I'm just going to have to blow my nose for 1 second. Sorry about this. You know the problem. Sorry, everybody. And then the polluter pays principle is in Article 3.2. Oh, that's the same article. And it says basically the polluter should, in principle, bear the cost of pollution. So it's very simple. The London Convention and Protocol regulates dumping of all matters into the marine environment, so from land and sea, including from ships. So there's a lot of toxic waste at the bottom of ships. So it covers that, but as I said, it also covers the removal of industrial infrastructure from the ocean, and that includes oil and gas platforms, pipelines, wells, etc. And I briefly touched on the environmental hazards that they pose. So the London Convention and Protocol explicitly applies the polluter pays principle. The next interesting convention, around this a similar time, the late 80s, is the Basel Convention on the Control of Transboundary Movement of Hazardous Wastes. And this again applies the polluter pays principle to hazardous waste management and international trade in waste. And really, that requires states to require a permit for any movement, any transboundary movement of hazardous waste. and it internalizes the waste hierarchy. So it says that the producing state needs to really deal with hazardous waste themselves. And it explicitly refers to the polluter pays principle, stating that the state of export should ensure that the generator of waste, not the state itself, but the generator of wastes within its jurisdiction, shall take all practicable measures to ensure that such wastes are managed in a manner consistent with the protection of human health and the environment, whatever the place of disposal. So again, that puts the obligation on the state to regulate. So that's a very early example of the duty to regulate, which I'd like to pick up in the conversation afterwards because I think that's quite interesting. So oil and gas cleanup. I'll talk very briefly about some of the challenges about with implementing the polluter pays principle in reality around the world. And I'll take oil and gas as the example because that's what we do at Polluter Pays Project. We focus on old oil and gas wells. So as oil and gas wells decline over time and as the well ages, greater investment is needed to maintain its productive capacity. When the well passes its economic limit, it enters what's called cessation of production, which means it needs to be plugged and abandoned, infrastructure removed, and remediated with ongoing monitoring to check for leaks, etc. So unplugged or improperly plugged wells leak methane, benzene, and other co-pollutants like PAHs that can leach into water, soil, groundwater, and air. And that has negative health impacts on local residents if they happen to be nearby. It also has a cumulative negative effect on the environment. However, decommissioning liabilities for oil and gas companies are typically very large, and companies are incentivized to avoid them in various ways. And they do this through three main methods. Firstly, divestment, second, delay, and third, dumping. And this is because of the monumental costs. So in figures, it's estimated that global decommissioning liabilities just for the oil and gas sector are 4 to 5 trillion US dollars. There are 29 million abandoned wells around the world. There are literally millions of abandoned wells littering the landscape across North America, Canada, and particularly the Western states, the oil producing states. So there may be a short-term financial benefit from that extraction, but there is a long-term benefit that the communities and people that live with that infrastructure on their land have to deal with and cope with. These abandoned wells emit 2.5 million tons of methane annually, and overall, 26% of the time, so 1 in 4 years, most companies cannot afford to pay for cleanup. So best practice environmental regulation that tries to address this problem has two key features, and that is firstly trailing liability, and that's a concept that allows the regulator to require a former owner of the asset to clean up if the current owner cannot meet those liabilities. And the second feature that's essential to avoid the various efforts that companies go to avoid these costs is upfront pre-funding of the decommissioning liability during the life of the asset. So that is to essentially require the company to save for cleanup during the productive life when the asset is making money. So like a pension scheme or like a superannuation scheme, mines, wells, and other industrial infrastructure also has to save for retirement, and they need to put that money aside into a specific fund. So where there is not trailing liability in law, we see patterns of divestment, asset divestment, to avoid decommissioning and cleanup costs. And this is common also in the global north. As I've said, that this is a huge issue across North America with millions of wells, millions of abandoned wells, but also in Australia in 2022, Woodside, which is the country's largest oil and gas operator, sold a floating storage and production platform to a small operator for $1. The purchaser then became bankrupt, leaving a rusting vessel leaking oil and toxic sludge next to East Timor. The Australian government acted quite quickly there, passing new legislation, including a levy, imposing costs across industry that raised that $1 billion required for the cleanup. And they also imposed trailing liability for the first time in Australia, which really sent shockwaves through the industry. A very similar scandal erupted in New Zealand, where a Malaysian registered company called Tamarin Taranaki became insolvent or entered, leaving New Zealand taxpayers with a $443 million bill to clean up an aging oil field off New Zealand's coast. And the purchaser, supposedly an expert in late life wells, used a loophole that didn't require regulatory approval to sell the asset. The New Zealand government then introduced trailing liability. However, the current government has reversed this in order to try and attract new oil and gas exploration, which I think is quite interesting. In Nigeria, some of you may know the toxic legacy of oil exploration in Nigeria. Many of the international oil companies there have sold their assets to local companies and essentially been able to walk away from those decommissioning and cleanup liabilities and that is because Nigeria doesn't have trailing liability. And again, across North America, there are millions of abandoned wells leaking methane and other toxic gases, just littering the landscape, affecting the farming land, so affecting agricultural land and interfering with other uses as well. So this is a global problem. Um, and the examples that I've briefly mentioned there, I think show that the corporate form and limited liability is often used to avoid liability, and very difficult for regulators to keep one step ahead of companies in these cases. Very, very challenging for them to address these sort of phoenixing, where a group of directors sets up a company, becomes insolvent, then goes away and sets up another company. So this is really common as well. And many regulators around the world, especially in the global south, they don't have the capacity to deal with these issues. And so this is one of the challenges that we're dealing with at Polluter Pays project. But I'll end there, and I'm looking forward to the rest of the discussion.
Wonderful. Thank you very much, Sophie. That was fascinating. And it's brilliant to hear all the work that the Polluter Pays project is already well underway in doing. So I've got plenty of my own questions because I am very fascinated in both of your presentations, but I will start by reading some of the questions that have started coming through in the chat box, and please do feel free to pop in any questions that do come up for either of our speakers in the chat box, and we can get a bit of a subsequent conversation flowing. So Sophie, if I can first pick up back on you just following your presentation just then, we have a question around the sea dumping protocol and London Convention, and whether these apply to deep seabed mining and waste, or is dumping defined in a particular way to preclude such applicability?
Oh, that's a really good question. That's a really good question. I'm not going to say that I can answer that off the top of my head. I mean, it is pretty broadly drafted. It's a pretty old convention. I think that would be a really interesting research point. I shall go away and look that up after this. Sorry that I can't answer that direct.
Not at all. Something that we can turn back to and circulate in our regular environmental lawyer network materials. So at the end of this, I'll have instructions for everyone on the line on how to sign up to that. Wonderful. So stepping back to the ICJ's advisory opinion, which both of you have mentioned, and is obviously probably one of the most landmark events of this year, let alone in climate law history in some respects. What do we have to say about the fact that the Polluter Pays commentary is directed at polluters rather than states? And as the advisory opinion itself was focused as a legal opinion on the state liability, but obviously had commentary on how that in part passes down to private actors by way of due diligence and some commentary around monitoring actors. We have a question in the Q&A function about, I might read it out in full for you. But the advisory opinion was about state liability. could it be said that the polluter pays principle is mostly about domestic liability for non-state entities? States are still potentially liable for harm caused by activities in their national jurisdiction, and a very specific reading of the polluter pays principle, but one that still makes it relevant under domestic law. So perhaps either of you, if you would like to pop in your comments around, and Matthew, Baird, this is your question. So if I have not given it justice, please feel free to turn your microphone and camera on and add any additional context or specific question for the speakers. But I think perhaps what this is going to is how do we adjust the polluter pays principle where we've got state actors and we're navigating, does it extend towards beyond their national jurisdiction? And was there commentary in the ICJ opinion around this? Jolene, did you want to jump in on that one first?
Sure, and then I'll hand it over to Sophie because I think she also has some really interesting thoughts on that. So I mean, I think in short, Matthew, I think that what you've written in the chat box is I would agree with it. Obviously, the advisory opinion was about interstate obligations, and it was an advisory opinion that would be focusing on state obligations. And one of the key things that I would say was very important that the ICJ emphasized was the duty of states to regulate private actors within their jurisdiction, and sort of asking states to ratchet up that regulatory obligation, and also to perform their duty with enhanced due diligence. And it also kind of mirrors what has been said by the Inter-American Court of Human Rights in their advisory opinion, which was, of course, articulated in the context of the Inter-American Convention on Human Rights, but also spoke to the issue of the polluter pays principle, and was more, and then from the context of business and human rights, was able to more directly articulate the relevance of the polluter pays principle in regulating private conduct. But absolutely, I mean, the thing is that if you want to use a very classical model of looking at international law, it's like with state to state. I think the court was also quite careful not to open up this conversation or open up this what are we talking about when we say you apply the PPP in interstate conduct, when the polluter pays principle is an environmental economics principle that has primarily been intended to be applied in the domestic context, or at least in the context of state regulation of private activities causing pollution.
And just I agree with all of that, but just to note that I think sometimes there's a little bit of kind of mixing up of the terminology, and people sometimes, when they say polluter pays principle or talk about making polluters pay, sometimes they're talking about loss and damage, and the concept of interstate responsibility as a whole, and the concept of loss and damage as described in the UNFCCC and as referred to in the AO. So sometimes polluter pays terminology is also used for interstate responsibility, which can, mean that one needs to just make sure that you're clear about what exactly you're referring to.
No, absolutely. Thank you very much, both, for addressing that. And I guess on a similar note, we've just had a question come in regarding the fact that whilst we haven't mentioned it thus far, there was back in May the loss advisory opinion on states' obligations in UNCLOS, and didn't specifically mention the polluter pays principle. It did touch on obligations of states in some capacity, but I guess that goes, Sophie, as well, to the complexity of having conventions around sea dumping and where polluter pays principle lies in that realm of international legislation. So yes, very, very interesting. And I think what was also great in the ICJ opinion was how it did step through those the state's responsibility to monitor private actors, as you've stepped through very well, Jolene, which hopefully It's a good point. So we've got another question that's just come through from Dr. Judith Preston about the role of the super fund trust model for preventing companies running out of their responsibilities and having funds to properly clean up. Sophie, is that one you'd like to jump in and take?
Yeah, thanks, Judith. It's really important. I think particularly in the United States, I mean that's where super funds for contaminated land have come up, and also they've proposed a super fund for greenhouse gases. The states of Vermont and New York, I think, have still got legislation said to require a super fund. I mean, essentially, it is like a publicly backed fund that pulls resource from industry to deal with contaminated sites or other cleanup work that needs to be done. But I will say that these kind of schemes are not a panacea. They need to be very carefully designed to be effective, and the regulator needs to have sufficient, resourcing and sort of capacity to enforce. So there's a sort of super fund in Alberta and Canada for orphan wells, because these abandoned wells are called orphaned wells, and it's called the Orphan Well Association, but it's run by industry. So industry got together and they said, well, we'll run the super fund. And of course, they set their contributions at a level that they prefer and can afford and would like to pay. And accordingly, there's just simply not enough money in the fund to deal with orphan wells, and it fails to meet its targets every year. It's been, widely derided and said to be a failure. So it's really, those kind of super funds can be subject to industry capture. And again, it's just really important to be so careful in the design. We say that it's most important that each asset, each well has to have its own fund, its own individual fund that is funded through profit when the asset is at its most productive, not when the asset is at its end of life. Because there are also some schemes for mines, and this is a massive issue in mining as well, huge issue. And a lot of the schemes only require the mine to start paying into the fund in the final 10 years of the mine's life. And of course, that's when the profit is absolutely decreasing. So you get into, from a commercial perspective, you enter this kind of death spiral. And the transition to a clean economy is making all of these cleanup obligations come forward in time much quicker. So this problem is a growing problem. And I'll end there. I hope that answered that question.
Very much. Thanks, Sophie. But coming off the back of that, you mentioned the duty to regulate and that there might be a role for that in having a bit more oversight. Is that something that you think you could see having a role there?
I think it's really interesting that Judge Bandari mentioned the polluter pays principle so clearly and made that link and said this is an opportunity to talk about accountability. Because when and pulling from what the Inter-American Court has said about the duty to regulate, it was really clear. Now for greenhouse gases, I mean, there are several options that one, obviously can take, and that states do take, many options that states have taken to regulate greenhouse gases, but the polluter pays principle ought to and generally is a fundamental principle of best practice regulation, environmental regulation. And as Jolene mentioned, carbon taxes, I mean, that's really obvious. But I think that there's possibly more to say on that, drawing on international law, and I'd be keen to know what Jolene thinks.
Thanks so much, Sophie. Sorry, Lily, would you mind if you just repeat the question, because I was just listening to Sophie and I kind of lost track of the question.
No, not at all. We're just coming through the limitations in enforcing rehabilitation and decommissioning responsibilities in the polluter pay principle, and how the duty to regulate might come in to interact with that, particularly from an international perspective from your comments.
Right. So I think one of the things that it's for me when I read the advisory opinions, and I think there's another comment in there that refers to the other the earlier advisory opinion that completes the trail, the ATLAS one. The three advisory opinions really come together to really collectively and unanimously and very loudly say states need to improve their efforts because they are legally obliged to address the global climate crisis. And if we take the starting point for why there was even a request to the ICJ for advisory opinion and to the ATLAS and to the Inter-American Court of Human Rights, it's because the current the current climate change regime has been, has been seen as lacking the kind of enforcement and compliance and accountability pathways that are needed to really deliver for kind of to basically to address the climate crisis, whether it's mitigation, adaptation, or loss of damage. I wanted to jump back to a point that Sophie made earlier about terminology, and I think it's really interesting because polluter pays principle. It sounds intuitive because, and I think when I saw Polluter Pays project website, Sophie, I really liked the one of the lines in there, which is, it's common sense. You make a mess, you clear it up. It's, anybody knows that since you were a kid, you were told, like, you make a mess, you clear it up. So it sounds very intuitive, and people naturally, I think, in a lot of conversations I've had, think that the application of the PPP is you pollute, you pay, and you pay climate reparations. So there's been a conversation about climate reparations and loss and damage, which tends to be hinged on this idea of polluter pays. But actually, I think when we look at the ICJ advisory opinion, the stronger and normatively more sound, to me at least, basis in international law is state responsibility, not polluter pays principle. I'll leave it at that because it sounds controversial, and I think it might be the best point to stop.
Not controversial, Jolene, definitely an important point to make. But I guess coming off the back of that, we do have a comment from Hubert from the Climate Justice Centre at Monash University that, well, given the rise of bankruptcy and polluters disappearing and, perhaps controversy around where the polluter pays principle does sit, do you think the practical issues of enforcing polluters to pay might result in the principle being overlooked, like arguably in the International Court of Justice's opinion, or being eroded over time through shifting legislative reform?
Yes, absolutely. I mean, it's just the challenge of effective environmental regulation and the pressures that the states are under to concede on a lot of these points to try and attract what they see as foreign investment. I mean, the polluter pays principle in many ways in all of the jurisdictions in which we're working on this cleanup issues, that it's eroded in many different ways. But maybe also picking up on what Jolene's said, which I totally agree with, there is that reparations for big companies and accountability of carbon majors, which is sometimes conflated with state responsibility in international law. I agree, international law doesn't say much about that. But what does help, and this is where actually you can go, is private law. And what we see is people are going to private law, where the concept of reparations again and polluter pays, common law in common law systems and civil law in civil law systems has concepts of reparations for harm caused by pollution and other activities. And if the public sector and if the regulator fails, which they so often do, many people turn to private remedies. And so for example, we've got cases, individuals bringing the case against Shell in the Netherlands, the Milieudefonsie case, and a group of Dutch individuals. You've got the Holcim case, the Indonesian islanders bringing a case against Holcim for sea level rise on their home due to that cement company's emissions. You've got the Ilua case with Peru brought against Germany, so a civil law system there as well. So these claims are in train in the US. They've been, where private law is a really important part of environmental regulation because there is so little statute, and the regulators are somewhat lax. They rely on private law to fill the gap. And so I think nuisance, negligence, and those claims have a massive role to play here. In the orphan well context, in the US, you've got groups of landowners where they've got abandoned wells on their land, and they are litigating against some of these companies that have allegedly phoenixed themselves and sort of dumped assets into an entity that's got no capacity to pay, and they are claiming fraudulent transfer, nuisance, negligence, and trespass on their land. And that case, so one group in Pennsylvania settled, and another group in Colorado is going to trial currently now. So there are some interesting developments in that space.
Thank you very much, Sophie. Jolene, did you want to pop in and say anything in response to that as well? No.
No, I
only
think
thing I
so.
would
Yeah.
The only thing I'd add to that, Sophie, thank you very much, is that obviously we are seeing that body of tort law, which is fantastic, but also on the other side of that, where we don't have tort law that is amenable to enforcing somewhat of a polluter pays principle, where we might be seeing human rights frameworks stepping in and being that avenue that can be used, for example, in the Agenda case, and perhaps arguably why in some instances the tort litigation in Australia hasn't been successful today. So a lot of different emerging trends. And with the last few minutes, I'm going to wrap in. Oh, we've gotten a few more questions. So firstly, yes, subject to Jolene's consent, we can circulate Jolene's slides, if that's okay, after the webinar. And there'll also be a recording available for all registrants. And I'm just going to loop in last two questions and also just ask for Sophie and Jolene if there's any kind of final remarks, perhaps more forward-looking optimism, if there is, that you'd like to leave the audience with, and perhaps looping that in. Is there a possibility at a global level, do you think, to have some kind of a uniformity in the implementation of the polluter pays principle through legislative reforms at different states, through a global initiative? And could perhaps the UN special rapporteurs or complaint mechanisms, like the Torres Strait case, Sophie, that you were very heavily involved, play a role in the future in attributing responsibilities to polluters? So there are two final very good questions, and perhaps if you want to reflect on those and add any final remarks that you'd like to leave with our audience, that would be wonderful, Sophie and Jolene. Thank you very much.
So perhaps I would take one question first, and then maybe Sophie could take another, and then we will see where we lead to. So you were asking about whether there could be uniform application of the polluter pays principle. So what I think is really striking is that most jurisdictions have very model legislation. And when we look across most environmental laws across the world, the polluter pays principle does shine through as a basis for designing environmental laws, simply because I think it's pretty commonsensical, right? Why should the state have to bear the cost of all environmental cleanups? And if it does, it has to justify, so there is a lot of application of the pays principle in the design of laws and rules, but the problem lies in the enforcement. And I think Sophie really mentioned this a few times, and I think it's really important. It's in the enforcement. Like, if you imagine that there are hundreds and thousands of abandoned oil wells across North America, imagine what it would be like across many other developing countries where the challenges of enforcement are dire. And I think it's also important to recognize that a lot of the oil exploration and exploitation in developing countries is done by transnational corporations, which are even better at phoenixing. I love that term, Sophie. I'm going to employ that in some of my later work, because it's just such a great figure of speech, because it really explains what corporations do. And so it's always saying one step ahead. So I think the question isn't so much about the application, but really how we need a lot more polluter pay projects because the enforcement is really the challenge.
Yeah, I completely agree. I mean, that's we are trying to enforce the law in some countries. I mean, Nigeria, for example, really challenging to even know what the regulator has done.
Well,
um, Really difficult. In countries like Australia as well, sometimes it's also really difficult to know what the regulator has done. So transparency is a challenge. How does the public know what's going on? But I think Jolene picked up on one of the fundamental points around the polluter pays principle. The general public gets it. They understand that when a mess is made, they expect the person or the company that made that mess to clean that up. And these scandals around abandoned mines that are leaving, toxic substances flying over, being blown onto communities, oil and gas cleanup that costs the taxpayer, hundreds of millions of dollars, billions of dollars. That's not acceptable to the general public, and that's not acceptable to the taxpayer. And so that's really where I hope that the public pressure can be brought to bear. I think it's also really interesting that if you take into account cleanup costs for oil and gas, if you remove those cleanup, if you often companies get a tax break for cleanup. If you take away the tax break that they get and compare that to the royalties, the actual royalties over the life of the asset are much lower. So that's an interesting point to make, I think, to many developing countries who are choosing their choosing their energy pathway. Will they go with renewables or fossil fuels, and what's the kind of cost benefit analysis there? So we're trying to do that sort of work. Lily's asked me a question about the UN Special Rapporteur system. I mean, I think I still believe in the UN human rights system, but I think we'd all, we have to admit that it's taken a bit of a battering lately, and that there are real challenges in the world right now around fundamental compliance with fundamental human rights, and the influence of the UN system and the UN special rapporteurs is somewhat decreased. I would say I feel that that has shifted quite a lot in the last few years, unfortunately, and that's just the geopolitical situation that we're in. And I think again why it's important to strengthen all human rights and at all times ensure solidarity, because human rights are indivisible actually. And so for me, I think that's part of the reason why it's important to um, support human rights at all times across all issues, not just environmental issues.
Absolutely, Sophie. I think that's a really, really nice note to end it on. And absolutely, the importance of human rights. And we've had some articulation on the right to a healthy environment, which has been exciting, and particularly coming out in the ICJ opinion as well. But I think that's a really good point to end on. And thank you very much to Sophie and Jolene for all your remarks today. It's been really, really insightful, very valuable, and I'm sure everyone on the line has found it very helpful. Thank you, everyone, for the questions that you included. We will circulate the materials from the presentation, also a recording of the webinar, and also some instructions on how to join the LAWASIA Environmental Lawyers Network. This is the 5th webinar in our series, and we've done previous webinars on different topics, including space law and environmental law and that intersection, some more around academia of environmental law thoughtship. So there's always a range of different topics to unpack. As we've appreciated today, we could have had this session going for all day. But thank you very much, Sophie and Jolene, and everyone on the line. Much appreciated having you here today, and we'll hope to see you in future webinars. Thank you very much.
Thank you, everyone. And thank you, Lily, for putting it all together with your team. Thank you.
Thanks very much. Bye.
Bye.
Bye.